all the things out.
My Lord, I beg leave to call the matter of state. This is Nkuli. The accused is before court. The matter is on roll today for argument in respect of sentence, my Lord.
I confirm still appearing for the accused in the matter.
Right.
My Lord, and I'm still appearing on behalf of the state in this matter.
Right. You have the duty to begin.
As it may please the court, my Lord. Essentially, in opening, insofar as the matters that relates to today's business is concerned, the defense has decided to start from an angle which I took cue from His Lordship's remarks, not only yesterday, but also on other previous instances when this matter came before court, namely that this specific case has generated public interest of an unusual nature. The question that I grappled with, that I had to ask myself on behalf of the accused, is why such interest when it is in fact with respect and in common parlance being a charge of a murder where it involves two parties. I find that despite everything else and anything else that has transpired during the trial, pre-trial and everything, that at the end of the day, this is attracting public interest and the media and everybody, because it is one of the most tragic love stories in the new South Africa that we have today. It is tragic because not of the attributes that one can put on the Shakespearean approach insofar as the Romeos and Juliets, where the one lover takes their life and the other their life because they are denied to be in love with each other. It is also not generating interest because of the classical John Keats poetry, where one can draw from the 18th century poetry of La Belle Dame Sardamesia. My French is not that good. The interest generated from La Belle Sardamesia is the mystery surrounding as to what is it that precipitated the death of the knight, despite the lovingness and the loving nature of what seems to have pervaded the couple, namely this beautiful woman and this knight. I am going to submit with respect, my Lord, that this matter has generated such public interest because, amongst others, it's a reflection of our society today as it stands, beside being one of the most tragic love stories in South Africa. It's a reflection on modern society of the danger-based violence, whereupon the original victim, because they took a decision to assert themselves, became a villain. That is the crux of as to the reason that prompts this much curiosity. And the curiosity stems from the following. The public out there, a certain sector of our generation and society that finds themselves in the circumstances in which Ms. Nkuli found herself, being an original victim and end up being a villain, as to how do our courts in this modern society, the modern democratic society, react in such circumstances. It is also some kind of public wonder as to how the court will interpret the predicament of the now villain who was originally a victim. Is it going to react and navigate with sensitivity? Is it going to react with humanity? Is it going to react with indignation? Is it going to react with revenge? Those are the questions that draws so much energy around this specific trial. Otherwise, as the Honorable Court found, and on the basis of the court's reasoning and finding that the accused's fault lies in her judgment of what was sufficient to repel what, in the circumstances, had she not used excessive force, I submit, would have entitled her to the defense of private defense. And I do not intend to bother your Lordship with a string of authorities because the lines are clear. It's either today His Lordship is going to send Ms. Manuela to jail directly for having overstepped the mark, or your Lordship is going to give her the benefit of a second chance and act with the sensitivity that goes in line with the dictates of our Constitution. And to that extent, I have prepared brief, and very brief, I must say, my Lord, heads of argument that are not extensive, just so that the court could be in sync with where the defense is coming from. I have given my learned friend, and as I explained, they are not extensive. And I begin by saying that the accused was convicted of one count of murder involving the use of a knife which resulted in the death of her boyfriend year after the deceased, pursuant to her plea of not guilty. The accused cannot be blamed, or at least be held or seen in a poor light for having raised a plea of not guilty, because she rightly believed that it was within her rights to resist the attack that she had been subjected to. However, the final judgment as to the correctness, justification of that conduct lies with the Honorable Court, and it is within His Lordship jurisdiction to so find. The Honorable Court found that the accused exceeded the bounds of self-defense. She stands to be sentenced on the crime, and the matter is liable to be disposed of in terms of the provisions of the Minimum Sentences Act. And essentially, what needs to be assessed today is accordingly, one, the appropriateness of the sanction that should visit the conduct of the accused. Whether the Honorable Court ought whether to impose the prescribed sentence in regard to the count of murder. And finally, what approach to adopt in the light of the apparent harshness of the impending punishment. My Lord, I'm not going to delve into the personal circumstances of the accused. They are a matter of record. We've called at least 3 experts that I submit with utmost respect have done a good job of it. Those reports include the reports of the Correctional Supervision and other related reports. My Lord, in terms of Section 12 of the Constitution, everyone has got a freedom and of security of person, which includes the right not to be deprived of freedom arbitrarily without a just cause, not to be treated or punished in a cruel, inhuman, and degrading manner. I am highlighting this specific aspect of the Constitution insofar as the other rights are concerned, because it became apparent during judgment as to whether it was made clear what rights of the accused on the evidence that has been presented appeared to have been at stake. I submit with respect that having been restrained and disallowed to leave the bedroom as she intended to against her will amounts to the deprivation of liberty. I am going to submit, my Lord, that having been subjected to the brutal physical attack that we have shown through medical evidence, that amounted as well to deprivation of her bodily integrity. Having been sawn at and called names and have your face spat on cannot be described any lesser than being some indignifying kind of treatment that anyone can receive. And this is the indignity that the Constitution that we all have sworn to abide by, in fact, preaches. And it is immediately and in the same time frame and in the same episode that the accused, when she tried to get away and having tried everything that she did, that she needed to react in the way that she did, unfortunately, she overcooked her pot. Now the question is, for having added too much salt, or for having overstepped by a certain degree, does that make her a candidate for incarceration? Put another way, I submit, my Lord, that wouldn't that be seen as an extenuating and compelling circumstances that ought to, amongst other factors, persuade his lordship that indeed a deviation should be considered from the prescribed sentences. It is submitted further that the court is confined to act in its discretion within the ambit of Section 2761 of the Criminal Procedure Act. In other words, your lordship's discretion has never been taken away. Rather, an emphasis has only been put to state that in deviating, all consideration should be taken of the offense. And consideration of the offense, I submit with respect, consists of all factors relevant to the nature and seriousness of the criminal act itself, as well as all relevant personal and other circumstances relating to the offender, which would have a bearing on the seriousness of the offense and the culpability of the offender. Now, unlawfulness with respect, and there are innumerable authorities to that, is a reflection of the moralities of society. The question that I ask myself is whether in our modern and moral society, is it irreprehensible for the court to afford an offender that is found to have exceeded the bounds of self-defense when she was rightly within her right to defend herself by a certain margin, to incarcerate them? I submit with respect that the answer should be that the accused must be afforded the benefit, and that on its own amounts to a compelling and extenuating circumstance that should influence his lordship to act otherwise than prescribed.
Which paragraph are you?
I'm expatiating on 3.2.
Yeah.
And in 3.3, in terms of the locus classic case of State versus Zinn, what has to be considered is the trial consisting on the crime, the offender, and the interest of society. It is also clear that in addition the approach to sentencing by judges must be considered within the prism of the Constitution. It is submitted that the ultimate purpose of punishment in a modern and democratic society such as ours is to strike a balance between the interest of society, the interest of the offender, the interest of the crime itself, and any other relevant factors, including the Constitution. I am in no position to downplay the seriousness of the charge of which the accused has been convicted. I will be the first one to concede, and undoubtedly so, the accused, that the charges that is standing to be punished for are serious and seem rather prevalent. The interest of society in this instance inevitably call for protection in the light of the seriousness of the offense that the accused has been convicted of. However, in this specific case, my lord, it is submitted with respect that the nature of the impact to society is rather indirect and distinguishable, as his lordship would have made from the various reports of the experts that testify that the accused has no propensity towards violence. This appears to have been a once-off instance, regardless of the tumultuous relationship that the couple had. It would seem they managed to either kiss or dance it away, as it appeared with the evidence that is before court, that shortly after the conflict that appears to have been at the sense from the evidence of the witnesses that they were, shortly thereafter they kissed and made up and danced after that. And my lord, it would seem that this was one of those once-off and unfortunate instances, and should therefore be distinguished from those that are likely to manifest themselves if the individual offender is released into society, such as serial rapists, serial killers, and offenders of that nature. And in any event, it appears on record that the accused is a first offender. The offender's interests have been set out in various reports, and on paragraph 4 I state that it is submitted that the aggravating circumstances in respect of the conduct of the accused ought rightly to be characterized as one of violence and one that resulted in loss of human life, which the courts particularly take deep view of and rightly consider irreprehensible. However, having characterized her conduct as that fraught with an element of violence, the court did not find that it was premeditated within the context that premeditation should be understood to be, such as where contact killing, where one has got sufficient time. The evidence that has been accepted by the Honorable Court is that at the time that she took a decision and overstepped the mark is such that it would not have been where one can safely call it premeditation to the extent that that should and ought to be used against her, to the extent that it is an aggravating circumstance that excludes the existence of extenuating and compelling circumstances prompting this Honorable Court to act otherwise. It is considered further that perhaps overzealous self-preservation on the part of the accused appears to have been the ultimate motive, as it appears. Self-preservation being that of having to protect the rights that I've already expressed myself on insofar as the Constitution. It was not out of malice, it was not out of anger, and it was never found to be out of jealous at that particular moment when she did so react. But more than anything else, it was the self-preservation that is also protected in our Constitution. I can name one, but a few cases, such as the case of State versus Makwanyani, where the value of life, which the accused believed at the time, in the accumulation of the events of the evening that were unfolding that particular day, that she believed that, amongst others, her life was in peril, her bodily integrity was in peril, her integrity had been shredded to tatters. The accused pleaded not guilty to the preferred charge. However, she displayed remorse immediately after the unfortunate incident. My Lord, there is nothing from the conduct of the accused that can make anyone conclude or infer that she did not display any remorse from the onset, during or after the incident, and even during the trial of the matter. And in the absence of anything to the contrary, the court is not entitled, with respect, to simply want to attach the standard of remorse according to its beliefs or the way it sees them. It should be. We've got the evidence of expert witness here. And remorse, with respect, my Lord, shouldn't be distinguished between remorse by judicial officers or remorse by a criminologist. Remorse is remorse. It's a deep-seated feeling of loss, amongst others, and as described, and self-pity and pity, and also a humbling feeling of devoutness on the part of the offender. And, my Lord, has seen the accused break down from time to time, especially when it related to the final moments when the deceased passed away. It is also the evidence of the witnesses that have been called, and it's also common cause, besides being their witness, that the accused was so devastated that she attempted to take her own life. That, I submit with respect, is an indication of remorse rather than selfishness on her part. It would have been selfishness had she simply stepped the deceased and left the deceased to pass away without attempting to do anything to help her, and thereafter try to take her own life. But having realized that the things have gone awry from her overstepping of the mark, as the court found, she took the initiative and tried to make good of it, and unfortunately, it was insufficient. The incident, together with the other trials and tribulations as set out in the reports, indicates that she must be a broken and devastated individual, and the record speaks for itself. The specific circumstances surrounding the commission of the offense speaks volumes of itself, including the fact that what actually happened here is that she appears, by all indication, to have been the victim. However, she became the villain because the original villain became second at the end of it all by one attempt to resist the brutal attack on her. I submit that that should be sufficient to persuade His Lordship to find and record that there are compelling and extenuating circumstances present to justify His Lordship in imposing a sentence other than the one that is prescribed. Further, with respect, and the question is, what would then be, in the circumstances, an appropriate sentence, having said all that, having had all the experts? Any judicial officer of note will admit and state that to can come to the conclusion as to the presence or absence of guilt of an accused is not as difficult as the stage of sentencing is concerned. The stage of sentencing is difficult, and what makes it most difficult, I submit, is because here one is dealing with a human being. What makes it difficult is because human beings in their nature are unpredictable. They are unpredictable to the extent that the court has no way of telling whether the sentence that is going to be imposed will destroy the particular individual, rebuild the particular individual, or reform and or rehabilitate. What does the court have? Fortunately, we have provided His Lordship with information and data and called expert witnesses. And it is the view of one of our experts that we call that direct imprisonment in the circumstances does not seem to be an appropriate sanction. I am going to submit, my Lord, that if His Lordship cannot find its way of not imposing direct imprisonment, let it be. However, the question is direct imprisonment the only suitable sentence to impose without giving the accused the benefit of a second chance? My submission is a resounding no, because of the factors that I've already set out above. And even if His Lordship might decide to impose a suspended sentence, a direct imprisonment, I submit that there would be justification in the light of the totality of the facts before His Lordship to consider suspending that direct imprisonment in its entirety, for the reasons that arose from the evidence that is already before His Lordship. The second point for consideration is correctional supervision. I submit with respect that there is a general misconception regarding correctional supervision in that it is not considered to be a sentence. But those that have undergone that sentence will bear one out that it is one of the most difficult sentences and punishment. The only difference is that there is still a semblance of human interaction on the part of the accused that remains, but still serve their punishment in a way that will also make good to society the wrong that has been done, and also alleviate the burden to the state of simply locking away someone in a confined space, feeding them for 15 years, and thereafter releasing them. The benefits of correctional supervision have been expatiated upon by the criminologists, and I have no intention of repeating them. And I should also submit that the Honorable Court is of faith with same. And I submit with respect that it would not be inappropriate in the circumstances of this particular case to deviate and impose correctional supervision, and or impose, without prescribing to the Honorable Court, direct imprisonment, which is suspended, and in addition thereto, impose a sentence of correctional supervision if punishment is indeed the desired goal in the circumstances of this particular matter. And that would be my address, ma'am. Unless if His Lordship would want to hear me on anything specific.
You'll have a second bite of the cherry when you reply, sir.
That's the point.
Mr. Scritter?
My Lord, the point has been made that this incident flowed from a situation where the constitutional rights of the accused have been violated by the deceased, more especially in respect of her bodily integrity, my Lord. But the other side of the coin is that at the same time, the deceased had a right to life, which is ultimately the ultimate human right. is the right to live. And that has been taken away from him forever. Nothing this court can do can redress that situation, my lord, and that is the purpose this court is here. If one then want to compare constitutional rights that have been impaired, my lord, certainly the death of the deceased stand out way above that of the accused in this matter. My lord, I'm not going to rehash all the personal circumstances of the accused. The court is well aware of that. I think what actually stands out, it is submitted, is that the accused is an adult female. She appears to be a sophisticated person. She's educated. She appears mentally sharp. And there's evidence before this court that she has been of independent personality since a very young age. In respect of time spent in custody, awaiting trial, my lord, she was arrested on the 9th of March, and she was again released on bail on the 16th of March, and therefore spent a week in custody awaiting trial. The Honourable Court is aware of the purposes of sentencing. It has been referred to by my learned colleague. Obviously, the aspect of prevention, taking somebody out of society, imprisoning them, might prevent them from committing further offences. The aspect of retribution, my lord, and there's been, it seems in recent days, a deviation to place sufficient weight on the aspect of retribution, my lord. In the case of State versus Nkuli, 1993, 1 SACR 136 in Appellate Division, it was stated that society's abhorrence for violent crime, especially murder, must be given acknowledgement, my lord. And it's admitted that retribution did not simply fall away. That is still an aspect, an element that every court should look at, especially where a serious offence has been committed like the present one. The third aspect, my lord, being deterrence. Certainly would-be offenders should be given a message. It is clear that the conviction in this case was based on the exceeding the bounds of self-defence, my lord, but I will come back to this aspect, my lord, that if it is dealt with lightly, it might lead to society taking the law into their own hands. My lord, and obviously the aspect of rehabilitation, I will come back at a later stage. In respect of the seriousness of the offence, my lord, there's a prescribed minimum sentence applicable, the Criminal Law Amendment Act 105 of 1997. In section 51, subsection 2, subsection A, subsection Roman 1, prescribes that for first offender, where murder is concerned, there is a prescribed sentence of 15 years. That relates, my lord, to a murder which is contained in Part 2 of Schedule 2. That is a murder which is not included in Part 1. My lord, it's not submitted that this is a Part 1 murder. It is clear that it's a Part 2 murder, which means that the 15 years is applicable. However, Section 51, subsection 3 determines that there is justification for deviation from the prescribed sentence if this court is satisfied that substantial and compelling circumstances exist justifying an imposition of a lesser sentence. The court in those circumstances is required to enter those circumstances onto the record, my lord. My learned colleague did refer to certain aspects which he considered as being substantial and compelling circumstances, my lord, and I'll deal with that at a later stage. With regard to the interest of society, here one would obviously look, my lord, at the circumstances of the deceased and his family. It is clear that the deceased was an upcoming music star. He was at the beginning, it appears, my lord, of some greatness. He was divorced at that stage. He had two children, being Nkuli Flabba Habedi, a daughter, presently 14 years old, as well as a son, aged 2. The evidence indicates that both of these 2 kids are now staying with their respective biological mothers. My Lord, and it's sad to think that these 2 children will have to grow up without their biological father. Your Lordship has also heard the evidence of Mr. Habedi, the brother of the deceased, as to the impact the death of the deceased had on him personally as well as the family. And it's clear that the personality of the deceased was such that he was the binding force in the family. He was the one who kept them all together, my Lord, and he indicated that a huge vacuum has been left by the death of the deceased. It's submitted that it's also clear that the mother of the deceased has been severely traumatized by this incident, and even a year after the death, my Lord, it still has a huge impact on them as a family. My Lord, various reports have been handed up. If I may start with the report by Mr. Halley, the criminologist. One of the conclusions he reached that there was no psychological scars that could be ascertained as in respect of previous relationships, my Lord. And in the end, he concluded that the accused has shown remorse on the basis that she showed insight. My Lord, on this aspect, it is submitted that there's a difference between remorse viewed from maybe a psychological point of view, my Lord, and remorse as to be found by a court, my Lord, when sentence and appropriateness of the sentence is to be decided. It is submitted that if one have regard to the demeanor of the accused during the trial, my Lord, it is submitted that even irrespective of what was said in this report, my Lord, it appears that there's not really true and deep-seated remorse. First aspect, my Lord, is that the accused pleaded not guilty, and she maintained throughout, my Lord, that she did not act unlawfully. She did not accept that she acted unlawfully. She maintained throughout that she acted lawful during the proceedings, my Lord. With respect to the psychological report, the clinical psychologist, Mrs. Monyamane, her conclusions are as follows. Firstly, that there were no mental disorder found. Secondly, there was no personality disorders found. Thirdly, that there's nothing in the accused's psychological makeup that had any effect on her committing this offence. In other words, there's no reduced ability to make decisions, to understand the impact and the results thereof, my Lord. In respect of the report submitted by the Correctional Services, Mr. Mapitsa, he indicated, my Lord, that in fact the accused may be an appropriate candidate for correctional supervision. And the basis thereof, he said that she has got a fixed address and that she is able to be monitored, my Lord. My Lord, it is submitted, however, that the mere fact that the accused may be a suitable candidate for correctional supervision doesn't automatically mean that correctional supervision is an appropriate sentence in this regard, my Lord. Furthermore, Mr. Mapitsa confirmed that there are psychiatric facilities available in the prison authorities and that if required, the accused may receive psychological treatment, my Lord. My Lord, it is also submitted furthermore that it is clear that the court is not bound by these reports. Obviously, the court must take cognizance thereof, of the contents thereof, but at the end, it is still for this honourable court to make a final decision in respect of what an appropriate sentence would be, my Lord. My Lord, that was reiterated in the matter of state. This is Mate 2014, Volume 2, South African Criminal Records 298. My Lord, where it was recognized that court is not bound by the reports and the recommendation contained therein. With regard to the aspect of remorse, my Lord, there is in law a difference, and a crucial one for that, between regret for what I've done and true remorse. Regret might be the feeling that I'm sorry that somebody died, but not taking responsibility, while true remorse, my Lord, indeed means that I'm taking responsibility for the death of the person. That must be true and deep-seated remorse. The Learned Court, my Lord, yesterday already referred to the matter of State versus Machiti, which is a well-known case, my Lord, where it was indicated that there is a chasm between regret and remorse. My Lord, many accused persons may well regret their conduct, but that does not, without more, translate to genuine remorse. Remorse is ignoring pain of conscience for the plight of another. Thus, genuine contrition can only come from an appreciation and acknowledgement of the extent of one's error. My Lord, as I indicated earlier, it appears from the accused conduct and her demeanour during the trial that she did not really take full responsibility for her actions. My Lord, the same approach was followed also in State versus Martin, 1996, Volume 1, South African Criminal Records, 172, Witwatersrand, where it was found that there is often no factual basis for finding that there is true remorse if the accused does not step out to say what is going on in his or her inner self. My Lord, in the present matter, the accused elected not to testify in mitigation of sentence, my Lord. It was therefore impossible for the state to probe her state of mind. It was impossible to determine whether the remorse she actually expressed is indeed a true and deep-seated remorse, my Lord. And it's admitted that that aspect that she failed to testify herself, my Lord, negatively impacts in the consideration whether there was true and deep-seated remorse. The same was said, my Lord, in State versus Seegers, 1970, Volume 2, SA 506, an appellate division matter at page 511 at G. But in order for remorse to be valid, the penitence must be sincere and the accused must take the court fully into his, or in this case her, confidence. Unless that happens, the genuineness of the contrition alleged to exist cannot be determined, my Lord. And it's admitted that this court has been put in a position where it cannot properly examine the nature and the extent of any remorse, my Lord. Furthermore, my Lord, if I can refer to the matter of State versus Lister, 1993, Volume 2, SACR, an appellate division matter at page 232, it was stated, as the court quo was at pains to point out, the approach of a sentencing officer is not the same as that of a psychiatrist. The sentencing officer takes account of all the recognized aims of sentencing, including retribution. The psychiatrist is concerned with diagnosis and rehabilitation. To focus on the well-being of the accused at the expense of the other aims of sentencing, such as the interest of the community, is to distort the process and to produce, in all likelihood, a warped sentence. And your worship is well aware of this, that one cannot focus once one comes to the sentencing procedure on the accused alone. It must be seen obviously in the context of all the other elements that are relevant, my Lord. In these circumstances, my Lord, it is submitted that a totally suspended sentence, as well as correctional supervision alone, my Lord, would be a wholly insufficient sentence in the present case, my Lord. The submission made, my Lord, that a sentence of imprisonment would take away any possibility of rehabilitation, my Lord, is certainly not true. My Lord, it can never be argued that a medium-term prison sentence, my Lord, will take away the possibility of rehabilitation. The accused is still a relatively young person, my lord. It is submitted that medium-term imprisonment will impress the seriousness of her actions on her, my lord, and obviously will give her the opportunity, my lord, to rehabilitate. In conclusion, therefore, the submission is on behalf of the state, my lord, that this honourable court should seriously consider imposing a medium term of direct imprisonment. As a court pleases, my lord.
Right, Mr. Makubela, reply.
Very briefly, without having to regurgitate and belabor the record. Having heard my learned colleagues' submissions, I submit that the court, with respect, needs to be reminded, as a matter of emphasis, not as a matter of disrespect to the court, that each case ought to be adjudicated according to its own merits and demerits. He has made a number of very, very valid points. However, out of those valid points, there is what falls with respect on the state's blind spot, namely that these particular circumstances of this matter can be distinguished from the various authorities where insistence on retribution was actually called for and in fact followed. It is admitted that the deceased was an upcoming music star, and that the family will be and continues to be affected. However, having said that, and I say this with the utmost of respect to the family of the deceased and the court and everybody involved, that if everyone takes an honest look at the facts that are before court, it would be disingenuous to simply ignore the significant contribution and conduct of the deceased towards the event of the evening. And yes, the families are suffering. The accused also himself, herself with respect, is suffering and suffered a loss of a person that the record reflects and shows that he was in love with the deceased. It is not simply some vengeful act of violence prompted or motivated by anything else other than to resist the unusual violent conduct of the deceased on this particular evening. And unfortunately, she overstepped her mark, as the Honorable Court found. And therefore, it is unfortunate and the consequence of the entirety of the events that there will be casualties. Indeed, there are no psychological scars on the accused, and that has never been the defense version. It has never been the defense assertion that the accused acted because of some mental disturbance or inadequacies. The defense has been that the accused had to take a decision at a critical moment in order to defend her dignity, to defend her bodily integrity, to defend her life and all other aspects of her life at that given specific moment. We can go backwards and forwards about whether there was regret or whether there was a remorse. But having said that, I do not think there is sufficient basis to say that the conduct of the accused, by having pleaded not guilty, is indicative of the absence of remorse. It's like castrating a bull and then discarding it later because it cannot breed. The accused is presumed innocent. The accused has a right to a fair trial. The accused has a right to have his case or her case proven by a court of law. And in any event, the accused played open cards and hands with the court. She said, I stabbed the deceased. She never tried to hide about that. It is the court that found that in that conduct of a stabbing, which she admits, and if one wants to attribute remorse from what she says, yes, she has admitted to stabbing the deceased. She does not deny it. Unfortunately, the mark was overstepped to the extent that she did by the use of excessive force, as the Honorable Court found. The mere fact that she did not testify to express her remorse has been found not to be a sufficient and good basis to infer that an accused is not remorseful. As opposed to the Lister case that my learned colleague has referred to, there is a counter case of State versus Ferrari and others, 20042 SACR 454, and it's an SCA matter on why it should not be, the accused should not be seen in a poor light insofar as the matters of remorse are concerned by her failure to testify. The inference should be drawn from surrounding factors, and I submit with respect that the totality of the proven facts before an accepted court before fact before his lordship are such that it would rather be a scanty attempt to try and say that the accused did not show any remorse. And Mr. Mapita did not say the accused may be a candidate. He put it in unequivocal terms that in the light of, amongst others, that she's got a proper address and all other factors, including her personal circumstances, she is a suitable candidate. Now, it is for the court then to try and navigate and react to this set of facts and see whether it would be appropriate having regard to all the factors that have been submitted before his lordship. Yes, indeed, the court is not bound to follow the expert reports that have been submitted. However, the court must have a reason to disregard or reject those particular expert opinions if it does, and it must do so with judicial sobriety, not the sense of importance to the extent of feeling that my view or no view. The court is encouraged to be open-minded and be creative, and also take advantage of the developing attitude towards punishment that is developing within our society, namely when the correctional supervision types of offenses were brought to bear in our judicial system. Yes, it is true that it is not only the well-being of the accused that must be taken into account. Equally, the conduct, unfortunately, of the deceased in this instance cannot be ignored. Now, what makes the rights, bodily and life rights of the deceased more important than that of the accused? There is no criteria to determine that. The court is called upon to exercise its judicial wisdom and strike a balance of interest. And in the light of the totality of the facts that are before court, it is such that it will really be a total miscarriage of justice to impose the sentence that is applicable and or suggested by my learned colleague. That is all, my lord.
Right. The court is going to adjourn for tea now, and after tea, the court will pronounce its judgment in this case. Yes, they'll leave all these things here. I hope they won't interfere. You'll be here. Okay. And you don't have a cup for drinking. You know, to drink, you can bought it in front of so many people. Yeah. All right. Court adjourns.
All rise.
Yeah, of course. Just
of the Minimum Sentences Act, which I've already referred to, that is Act number 105 of 1957, whether it is applicable or not, and what has been said by the respective sides as far as this act is concerned. So I'll come to the Minimum Sentences Act. Now, let's deal with, so it's three things I'm going to talk about, three aspects. Let's deal with the first one. How does the court impose a sentence? Now, usually the court takes into consideration three factors. These factors are called a triad, T-R-I-A-D, triad. And that simply means a group of three. Now, this triad is a legal triad in the sense that it was pronounced by the courts before. It was expressly mentioned in 1969 by the court in the case of Rex versus Zinn, an appeal court case, and it was said that the courts, in imposing sentence on accused, must take into consideration three factors, namely the offense which has been committed, secondly, the offender, that is the personal circumstances of the offender, and thirdly, the interests of society. Now, this triad is somehow different from the one referred to by the criminologist who testified here yesterday. On page 20 of his comprehensive report, which is very helpful, 20 and 21, you'll see he refers to a triad as well. But now his triad is different. He refers to factors such as retribution and rehabilitation, and that punishment must have elements of discomfort, and that is, according to him, as expounded by a certain Terblanche who must be a criminologist, a triad of factors which have to be taken into account. I'm not talking about that now. I'm talking about what the courts are expected to do. And the triad is the offense, the offender, and the interests of society in general. Now, I'm saying these things and I'm trying to explain these things in simple terms because I know you know English and you are schooling in Ireland and you should be understanding what I'm talking about. In 1973, in the case of State versus Sparks, the courts, the highest court in Bloemfontein, said one should not only consider this triad, but to it one must add the fourth element, and that is the element of mercy. So I'm going to talk about four things, not three things, but I'm going to talk about the offense, the offender, you, and the interests of society, and in the end I'll talk about mercy. Now, the offense that you have been convicted of is one of the most serious this side of the clouds. anywhere. It is punishable in certain countries by death. Even in modern countries such as the USA, they still give you a poisoned injection for murder. And in other countries in Africa, they simply take you to the beach and they order the firing squad to fire on you for murder. So it's a serious offense in any society. In ancient times in Africa, one would be thrown down a precipice to die down there for having committed murder. It's serious. It's a very serious offense in any language. It smells even to the nostrils of heaven. It's so serious that you cannot think of any other crime which is more serious than it. Perhaps except treason or anything of the sort. Now, the circumstances under which this crime was committed are known. Lots of evidence was adduced by the state. Witnesses were called to come and testify about how it was committed. And we know certain facts about this crime, that it is a crime involving two persons who were lovers, and their love affair turned sour in the end. And the whole incident took place at different stages from the moment they decided to go to a place called the Sands in Sandton to go and enjoy themselves for the evening, and they exchanged very vituperative and obscene words. They were angry with each other and so forth. Then they moved from there to the parking lot of the vehicles there, and then they moved to buy Kentucky or McDonald's somewhere, and they bought some chicken, and then they drove to Alexander, and this exchange of heated words and obscene words like "you're a gold digger," "fuck you," and fuck was used so many times that one cringes actually to use it in a court of law. And it ended up in the room of the deceased. And we know that the deceased had been locked out of his own room, and he knocked several times at the door and the window and so forth. And at last you decided to open for him. You were inside. And as you were inside, this thing reached fever pitch now. You exchanged more obscene language and against one another. Very abusive type of relationship. And all of a sudden there was a knife there. We don't know who brought the knife to that room. And as you were clashing there, he was seated on you, and you are the only two persons who can tell us what happened in that room. But the other one is no more there. It's only you who testified about what happened in that room. And the court looked at that with at close quarters, and and looked at all the probabilities and drew its own inferences in terms of the law. Rex versus Blom is the case 1939 AD, where it used its sense to draw inferences about what was happening inside. And there were chaps seated outside in a relaxing area and so forth. But in the end, you yourself admitted that at one stage you had the knife in your hand, and it was no more in the hands of the deceased, but you had it, and you stabbed the deceased, and he simply succumbed to the stab wound, and he fell there, and you tried to help him and so forth. We know the background. That is recorded. It's in the records of the court. Now, that's how the crime was committed. The fact of the matter is that you took away the life of Nkuli Flabba Habedi, and you were so traumatized by the whole incident yourself that you even tried to cut your wrist by means of a broken bottle. You broke a bottle and cut yourself because you felt like committing suicide, I suppose, and so forth. Then you were arrested, and so and so that's how you got arrested for the murder of Nkuli Flabba. But that's the crime. Now, it is common cause that you raised a defense of private defense. That is, you say you were defending yourself. And the court, after analyzing everything, the evidence of witnesses for the state, evidences of your witnesses, the probabilities of a case and everything, the court arrived at the conclusion that no, you exceeded the bounds of private defense at law. And the court referred to authority on the point. If you read the judgment, which I'm told is not yet available even to your lawyers and to counsel for the state because of some hitches and glitches with iAfrica who are typing the record, you haven't seen what the record says, the transcript. But anyway, it's over 3 months now that thing has been in the hands of iAfrica, and by now it ought to have been obtained by whomsoever wants to see it. And so you exceeded the bounds of private defense or self-defense in that you plunged the knife you had in your hand into the chest of the deceased to an extent that the force you used broke his rib, and the knife penetrated to the lungs, and as a result he died. Now that is the crime you committed. Now whether that is justifiable or not, and whether that is private defense or not, it's another thing altogether. And if you call it private defense, I've ruled already that you exceeded the bounds of the limits of private defense. Now, that is a crime you committed. I've told you how serious that crime is anywhere in the world. If you take the life of another person in the world, you're no good. The you get punished for that. Whether it be the life of a child or a lover or an old person or not, that is not acceptable in any society. That's why I used words like murder smells even to the nostrils of heaven. I'm bold to say that. And now I've described the crime you committed, so it's serious, we accept, fine. Now the second thing is the offender, that is you. Now you, for some reason or another, counsel for the defense did not call you to the box to testify in mitigation of sentence or not, because if you had done that, counsel for the state would have had occasion to ask you questions on certain issues such as remorse and so forth and so forth. How remorse are you and so forth. But even if you didn't take the witness stand to testify in mitigation, you managed through your lawyers to call 3 witnesses who gave excellent reports on your condition, and it is from these reports that one is able to glean your personal circumstances. So your personal circumstances are that you were born on the 20th of February in 1989 in Newcastle, and this makes you about 27 years of age now. You are currently unmarried. So you are still single. Your highest level of education is matric. You passed matric. Your home language is Zulu. And your present occupation is that of a student. You are still a student. You attend courses overseas at a university in Ireland. So somehow you are learned. Now those are your personal circumstances, and your counsel ably led the 3 witnesses who testified on your behalf, and he even tried to supplement whatever they said about your personal circumstances. And so the court knows certain things about you from these reports and from what your counsel said. And one has a picture of you as a person. We know that you no longer have parents. We know that you are the only child left in your family, and your father died recently, and we were told what he died of, acute appendicitis, and we don't even know whether he was adversely affected by your actions of having killed Mr. Habedi. We don't know that, but he must definitely have felt bad about it, even if he was suffering from acute appendicitis. No one wants his daughter to be involved in crimes such as murder. And we know that you are left with the house where you're staying as your permanent address. This was mentioned by Mr. Mapitsi, in his suitability report, he gave your address and he told the court that you stay at 6156 Mudumela Street in Kempton Park, Birch Acres. And so we know where you are to be found at all reasonable times, or at all given times. And so what stands out is the absence of the religion you subscribe to. I suppose that is not important for personal circumstances whenever you are asked by these people, these experts. And this is a reflection of the South African society, as your counsel argued, that our society is such that certain things do happen, and if we were living in an Islamic society, I'm quite sure it would have been necessary for these experts to note the religion you subscribe to, whether you are Hindu or whether you are Muslim or whether you are Christian. But they did not do so. So that stands out like a sore finger. One can read these reports and one won't find that things there. Now those are your personal circumstances, madam. Then I deal with the interests of society, the third element of the triad. Now, as we get born and grow up and start schooling and so forth, even up to university level, you come to realize that society is organized in a particular fashion. Society has got authorities, for example. It has got law enforcement agencies. It has got courts such as these. Whether you like it or not, or whether you're studying law or not at university. But you come to realize that it's organized in a particular fashion. And society, being organized as such, has got courts of law. And these courts of law are there for a purpose: to punish and sentence those who commit crimes, and to see to it that that takes place. And it has people such as myself who adjudicate cases, and I would be failing in my duty, being an appointee of society, not to do what I'm doing now. So one has got to accept it, that we live in such a situation. And society expects those who commit crimes to be punished. They should be sentenced by the courts. You can't be punished by everybody, but you can only be punished by the courts. They impose sentences for that, and they make sure that you go through procedures that are fair, not only to yourself but to everybody else, to get to the bottom of the issues and to know why you committed the crime, and that you must be given an appropriate sentence by the court. So it is my duty to give you an appropriate sentence in this court for the crime you've been convicted of. It's part of societal requirements. Society expects me to do that. And I took an oath that I would do that, and I'm going to do it. Now, that is the third element, the interests of society. And when we speak of society, we're not speaking of people at Birch Acres or anything. We're speaking of the broader South African society. Broader South African society, even those in Newcastle and everywhere. And so we know that society expects us to get punishment for whatever wrongs we do. The fourth element, I'm still talking about the how we punish you, how we sentence you. This is how I take all these factors into account. The fourth element I take into account is the question of mercy. Now, like I said, it was in 1973, in the case of State versus Sparks, that the appellate division decided that to the triad, to the three elements, one must add mercy. Now, mercy is when I shower you with mercy, when I show you mercy. That does not mean that you're smart or you're clever or otherwise, and the court is stupid. But I show you mercy, and this is going to become apparent in the sentence I'm going to impose. I show you mercy because mercy is part of justice in itself. So if I'm going to dispense justice from courts of law, I've got to dispense mercy because mercy is part of that. Now, it's necessary to show accused persons and convicted persons mercy because we're not dealing with animals here. We're dealing with fellow human beings. And we must show them mercy if they go astray or they do things which society does not want. So you can be assured that this court is going to show you mercy, and this will become apparent in the sentence I'm going to impose. Now, that is the how of it. How the court sentences a person who has been convicted such as you. I now come to the second aspect, and I said is the why of things. Why do we do that? Now, in terms of South African law, there are four primary reasons of why convicted persons should be sentenced by the courts and why they should be punished. The first reason is one of retribution. Now, it's a technical word, it's a big word, and you'll read about it even in the reports of a criminologist. He talks about retribution in his report here. Now, for me to simplify retribution, I normally say, I normally give a background to where it comes from, how it started, this idea of retribution, and what it means in modern society, in our context now. Retribution is based on the idea of an eye for an eye, a tooth for a tooth. If you take out someone's eye, so we should take out your eye as well. Eye for an eye, tooth for a tooth. That is a retribution in its strict sense. It finds its origin in the code of an ancient ruler who was called Hammurabi. Now, that is so many years before the birth of Christ. So it was before BC, many years ago. And it was transported and it spread all over. And we received it through Roman Dutch law in this country, and it even went through Roman law and so forth. If you study the history of South African law, you'll find that it came all the way. Now, an eye for an eye, a tooth for a tooth. The question is, if someone rapes another, does he have to be raped as well? Does it make sense? Killing is something else, but raping is something altogether different. But if one applies an eye for an eye and tooth for a tooth strictly, then one has got to do that. Rapists should be raped. Killers should be killed, and so forth and so forth. Now, like any other idea, whether it be legal or sociological or psychological, it develops. And retribution has developed over the years. It has developed to an extent that we no longer apply an eye for an eye, tooth for a tooth type of notion. We no longer use that. Why? Because we've got a much enviable constitution in our country which seeks to protect the rights of everybody, including those of convicted persons. So our constitution then, which was referred to by your counsel so ably, is meant not only to protect you, but also it has also changed the notion of an eye for an eye, a tooth for a tooth. And in the present day context, retribution can be expressed in a simple term. And I usually say, if you do the crime, you must be prepared to do the time. You do the crime, you must do the time in jail. So this is retribution. In simple terms, in English terms, we say you pay your just deserts to society. You must be prepared to pay your just deserts to society. You must do the time and pay your just deserts to society. That is retribution. Now, that is one of the reasons why the courts have to punish convicted persons such as you. Now, I said there are 4 of these, and the first is retribution. The second one is prevention of crime. How does one prevent crime from taking place? Society being organized in this fashion I've delineated has got law enforcement agencies like the police and so forth, who are intended to prevent crime. The courts are there to make sure that crime is prevented. Even social institutions such as our churches, our schools, are supposed to teach a particular morality which is intended to prevent crime. So, prevention of crime is one of the reasons why convicted persons have to be punished by the courts. That's the second reason. If crime were not prevented, we would all be living like animals in the Kruger National Park, where the strong scratches the weak and kills the weak for a meal or anything of a sort. We would be like animals. And we are not animals, we are human beings. And we have laws and rules of morality for the prevention of crime. And we don't want to live like animals in Kruger National Park. The third one is deterrence. The third reason why the courts have to punish you is deterrence. To deter you, to stop you, to deter you from committing further crimes, from killing your future boyfriends, to deter you from doing so. But deterrence does not only apply to you, it applies to your ilk, your like-minded persons, those who are thinking of doing what you did. They should be deterred as well. Now, you grew up in your society and you are known to certain people, and some of these people are your friends, and some are relatives. And some will ask, what happened to Cindy Siwe, Precious? And if they come to learn that you were punished by the courts in a certain way, they will be deterred from committing what you committed. They won't just easily, do what you did. So, deterrence is one of the reasons why the courts punish convicted accused. It's a reason for punishment. The last reason is rehabilitation. Now, this has already been referred to by your witnesses, that is the sociologist. He also mentions it in here. Rehabilitation. Now, you'll surely agree that rehabilitation starts with the individual. You must be prepared to be rehabilitated. If you're not prepared to be rehabilitated, nobody will rehabilitate you. It starts with you. You must start by accepting that I have done wrong. What I did is very wrong, and society does not want it. And because of the wrong I did, I am prepared to be punished by the court, and I'm prepared to be rehabilitated, and I'll change. and turn over a new leaf and become a new person in future. Now, that is a rehabilitation. Now, this is exactly what Mr. Mapiti, your witness, said in his suitability report. He mentions certain facts which are used for purposes of rehabilitation. He pointed out that where he works, that is in the Department of Correctional Services, there are programs which are offered to help those who are incarcerated there to be rehabilitated. So they do help in rehabilitating people, and so we see that they want to achieve the same purpose which the law wants to achieve, that of changing people to be good citizens of a country and not to kill, not to allow them to kill others and so forth. Now, rehabilitation obviously cannot be a bad thing. It should be acceptable to anybody who's prepared to accept that he's committed a wrong, and that she should be exposed to such courses as are offered by anybody for purposes of rehabilitation. The questions were asked to the psychologist, Mrs. Munonyane, whether as a private practitioner she's able to gain access to incarcerated people to see to it that they are offered the courses or the knowledge which she has for purposes of rehabilitation. And she expressed the view that she's not sure about gaining access to such places, but she'll find out. Now, that is rehabilitation. I now deal with the last aspect of what I proposed to say when I started talking to you. That is the provisions of the Minimum Sentences Act. Now, you have been found guilty in terms of Section 51, subsection 1 of the Criminal Law Amendment Act, number 105 of 1997. 105 of 1997. Now, this law prescribes certain sentences, minimum sentences. It says for murder, you get nothing less than 15 years. 15 years upwards. And it even prescribes life imprisonment for certain offenses. Now, when this law was passed, many South African was not sure at what it was aimed at. The courts felt that their hands were tied by the legislature in prescribing certain sentences. It was taking away their discretion and so forth. But it turned out that that is not the case. This law only reflects what the state of affairs in South Africa was in the mid-90s. That South Africa was sick and tired of crimes such as rape, murder, and so forth. And the population sent politicians to Cape Town to make laws. And this is one of the laws they made. The Criminal Law Amendment Act number 105 of 1997. They said, let there be minimum sentences for certain crimes and so forth. And this is how it came into operation. And it turned out that it doesn't affect the discretion of the judge and so forth. And it even provides that where the judge can find that there are what are known as exceptional and compelling circumstances in the case, then the judge is entitled to impose a lesser sentence than that which is prescribed by the lawmaker. That's what it says. Now, in your case, having listened carefully to all aspects of the evidence and having applied my mind to the probabilities and of a case and improbabilities and so forth, and all aspects of the case, I found that in your case there are substantial and compelling circumstances which entitle me to impose a lesser sentence than that which is prescribed by the law. Otherwise, I did not have a choice. I had to carry out what the law says. And in this instance, I'm given an occasion, I'm given a discretion to find out whether there are substantial and compelling circumstances. And I have found that there are such circumstances. The first circumstance I find in your case is that the demise of Nkuli Flabba Habedi occurred as a result of a heavy confrontation between two people, you and the deceased, in a limited space that is in a room, his bedroom. And this altercation that occurred between you and him, as I have said yesterday, started earlier on in the day. At the sands and other places, and it reached fever pitch in the room of the deceased. So this heavy confrontation or altercation between you and the deceased makes both of you victims. The deceased is a victim of this heavy confrontation, but unfortunately he died. And fortunately you are still alive, but that does not mean that you are not part of this heavy confrontation. So, because the murder you committed arose from this heavy confrontation. If it were not there, it wouldn't have happened. Flabba Habedi would not have been killed if there was no heavy confrontation between the two of you. And so, both of you are victims of this circumstance. And I find that as a substantial and compelling circumstance. Secondly, I find that in your case, you tried to apply cardiopulmonary resuscitation, otherwise known as CPR. Everybody's been talking of CPR here. People speak now in computer language, CPR. Now, you tried to apply CPR on the deceased until you heard him groan and his eyes were popping out and so forth, but and you were helpless. You couldn't succeed in your CPR attempts. So it shows the level of regret and shock and trauma you received as soon as you had stabbed him. So there was a CPR applied by you, and I find this to be a substantial and compelling circumstance. Thirdly, I find that you are a victim of mutual jealousy between you and the deceased, and in your love relationship, it shows even in the reports that you have a history of possessive and abusive relationships in your love affairs. You would do well in future if you have to fall in love with anybody to make sure that you don't involve yourself in possessive and abusive relationships such as you've had and such as are clear from the records here. It was not only with Habedi that you had mutual jealousies with your lover, but even with the other lovers before or prior to falling in love with Habedi. So, being a victim of mutual jealousy in your love relationships, I take that into account and I regard it as a substantial and compelling circumstance. In the fourth instance, I have no doubt that the reports which have been submitted on your behalf by the experts, the psychologists, Ms. Munyamani, Mr. Mapiti, and Mr. Halley, all indicate that you are not inherently evil, and there is a great potential for rehabilitation on your part. You stand a good chance of being rehabilitated. And I've already spelled out the requirements for rehabilitations, that it starts with you. You must admit it that what you did is wrong, and be prepared to expose yourself to programs which deal with rehabilitation. Now that is the fifth substantial and compelling circumstance that you are a good candidate for rehabilitation. And lastly and fifthly, you are a first offender. You don't have a previous criminal record. Being a first offender, if you had not been arrested, I would have said you are not familiar with the inner walls of prison. But now you were arrested, and before you got your bail, you became familiar with the inner walls of Sun City, that is Johannesburg prison. But anyway, that does not detract from the fact that you are a first offender and you have no previous convictions. And these are the substantial and compelling circumstances I find in your case. And because the Criminal Procedure Act number 105 of 1997, that is the Criminal Law Amendment Act, enjoins me to put on record the reasons which I find, that is substantial and compelling reasons. I hereby do so now, that I commit them to the record, and I've mentioned 5 of them. And whomsoever is going to read the record at a later stage will find that the court has found such circumstances in your case, substantial and compelling circumstances. Now, Madam, it is, having said that, having dealt with the how and the why and the substantial and compelling circumstances in your case, it is now my unpleasant task to have to sentence you. If you could rise, please. Having had sight of the record and having visited the charge sheet and having convicted you of murder, the murder of Mr. Nkuli Flabba Habedi, it is my unpleasant task to impose the following sentence on you. You are hereby sentenced to a period of 12 years imprisonment. It is recommended to the Department of Correctional Services that the programs which are available to incarcerated persons, which are mentioned by Mr. Mapitsi on page 4 of his suitability report. And these are the programs: a life skills program, self-esteem program, anger management program, and other programs which are offered by the social work department of the Department of Correctional Services be offered to you, be exposed to you for the purpose of rehabilitation. You must accept them and try to make yourself available for such programs, and these you'll see from on page 4 of Mr. Mapitsi's report. In the second instance, it is recommended to the Department of of Correctional Services, the National Commission of Correctional Services, that you not be granted parole until you have served 2/3 of your sentence, that is 8 years of your sentence. And that, Madam, concludes your case, and may the good Lord be upon you.
As it may please the court, before the court can adjourn, subsequent to your Lordship's conviction finding in December last year, we already had instructions to note an appeal. And as of now, we had discussed also that with my colleagues, and I have instructions at this stage to bring application. And seeing that it's now after lunch, I wish to ask the court if I could bring my application for bail pending an application for leave to appeal, and I'll state our reasons for that.
It's not after lunch, you know. There's still time.
We can be ready in the next 10 minutes. You simply have to print out and make adjustments in our affidavits, because we had already prepared something insofar as conviction is sentenced. Just need to complete.
Bail pending appeal, you say?
Bail pending application for leave to appeal.
To appeal,
yes.
Yeah. And you say you have prepared a document as well?
Yes, but then there is a part which we did not address, which is going to be very brief insofar as the sentence part is concerned, and also to have the affidavit commissioned. But the documents are almost ready. We won't take more than 10 minutes of His Lordship. So if we can adjourn now, we can be ready in the next 5-10 minutes. It's in print and ready to, it's just a matter of pressing a button.
Mr. Schutte?
Yeah, my Lord, I have no objection if we stand down the matter for the preparation of the application. I think it's appropriate that it be dealt with immediately.
Within 5 minutes' time.
That
All right?
5 will be okay, ma'am.
The court adjourns for 5 minutes?
You got a court order here or in Luguzana? Or an AT? No, they don't commission.
Right?
As it may please the court, my lord, we are indebted to his lordship for the indulgence. As already indicated, that my instructions are to bring an application for bail, pending application for leave to appeal against both conviction and the sentence and the outcome thereof. To that extent, we have prepared the affidavits, and might I beg leave to hand in an already signed affidavit, which I propose to read into record, and will subsequently request that it forms part of the record of this part of the proceedings. And then and I proceed to read it into record as follows. In the High Court of South Africa, Gauteng Local Division, Johannesburg, sitting at the Palmridge Magistrates Court, case number SS-52-15, in the matter between Manele Sindisiwe Precious, the applicant, and the state. Affidavit in support of application for bail pending application for leave to appeal against both conviction and sentence and the outcome thereof. I, Sindisiwe Precious Manele, states as follows. The contents hereof fall within my personal knowledge, except where otherwise stated, and are, to the best of my knowledge, true and correct. I am the applicant in the matter. I make this statement in support of the application for bail to be reinstated or set in my favor pending the application for leave to appeal against my conviction and sentence by the Honorable Court, as well as the outcome thereof. On the 9th of December 2015, the Honorable Court, having convicted me of murder as originally charged, ordered that I be kept in custody as my bail privileges lapsed pending the finalization of the matter. I was subsequently granted bail by the Honorable Court on the 10th of December 2015 after due application. I have since been sentenced by the Honorable Court today, and the matter has reached finality insofar as it relates to the child court. I am advised, which advice I accept to be correct, that in the light of the nature of the charge I have been convicted of and sentenced, this bail application falls within the purview of the so-called Schedule 5 bail instance. I further appreciate that it shall be incumbent upon me to show on a balance of probabilities that there are factors and or circumstances present, the existence of which justifying my further release on bail in the interest of justice. I further appreciate that the constitutionally entrenched presumption of innocence that is usually operative is somewhat inhibited or can effectively weigh in my favor since I have now been convicted and sentenced. I confirm that I have previously instructed my legal team to bring an application for leave to appeal against my conviction, and further today to do it in respect of the sentence as apparent from the proceedings. In the meantime, I have instructed my legal team to secure the transcripts of the Honorable Court's judgment and now sentence proceedings, which information is required to prepare a substantive and comprehensive application for leave to appeal both the conviction and sentence. My legal team has already applied for on an urgent basis for the transcripts of the record of proceedings and judgment of the Honorable Court as of the 6th and the 14th of January 2016 in order to commence with my instruction as above. I attach proof of the request and correspondence to iAfrica transcriptions as SPM1 to SPM4 of this affidavit. I am advised that they have so far, my legal team that is, secured part of the record of the proceedings, which did not include the judgment of the Honorable Court. There has apparently been some contractual logjam between the Department of Justice and iAfrica, which has had the effect of precipitating the delay of delivery of transcripts in general. My legal team is yet to receive the full transcripts of the Honorable Court's judgment and will hereafter make a further application to iAfrica for the transcripts concerning the sentencing proceedings. In brief, and without going to detail with the pending application for leave to appeal the conviction and sentence, I am advised that A, the factual and legal findings of the Honorable Court based on the evidence before it will be challenged. B, the meaning and application of the principle of proportionality between the Defensive Act and the harm caused within the context of private defense will also constitute the crux of the challenge to the conviction. C, the fairness and appropriateness of the sentence in the light of the facts and circumstances of the matter also will be challenged. I am advised that the turnaround time for the process and procedures that I will now engage and set into motion to assert my constitutionally entrenched remedies as enunciated above will require a period of about a month. Taking into account that not much can be done without the transcripts, my release on bail in the meantime will be in the interest of justice, as the prospect of this court granting me the leave sought are favorable in the circumstances I submit. I, however, submit with respect that the course adopted by my legal representatives in this regard is necessary, since it will be in the interest of justice to do so, that is securing the transcripts and so forth. At the inception of this matter, I remained in custody until a formal bail application was held and subsequently determined that I was not a flight risk nor a danger to the public, and that the interest of justice favored my release on bail despite the serious nature of the charge. I was granted bail at the sum of 10,000 rands plus further conditions to report at mid-rand SAPS on stipulated days and conditions. No finding that any other interest of justice stood to be prejudiced by my release on bail was made at the time. I religiously adhered to the conditions and attended court throughout whilst on bail until the Honorable Court convicted me of the offense. There was no occasion I did not attend court, as this Honorable Court remains better placed to know from the record of proceedings of this matter. Despite the probability of an adverse finding accompanied by the probability of a severe sanction in the light of the charge that was preferred against me, I remained in attendance because I have an informed confidence in the judicial system of the Republic of South Africa. Except for the existence of the present conviction and the now imposed sentence, very little has changed other than to the extent that I have and continue to indicate to the court. Insofar as my personal circumstances, as was submitted during my pre-trial formal bail application, and at all relevant personal circumstances that emerge emerged during the sentencing stage of the proceeding, little has changed insofar as my personal circumstances. I submit with respect that I have shown myself to be a person that believes in exploiting and exhausting the legal process and remedies against my legal woes than to resort to being a fugitive from justice. I am advised that the test that the Honorable Court will apply in order to evaluate the merits or demerits of my application remains whether there exist facts on the basis of which it has been shown on a balance of probability that the interests of justice permit my further release on bail pending the finalization of the matter. I am further advised that the main thrust of the Honorable Court's verdict of guilty was that although I acted in private defense as apparent from my plea, I seemingly exceeded the boundaries thereof as opposed to a determination of premeditated conduct. I have been on bail in the amount of 15,000, which amount is available still for the same purpose, and I am able to augment same should the need arise. I humbly submit that any hurdles to deny me bail pending the outcome of my pending application for leave to appeal as stated above have been adequately addressed. The imposition of further stringent conditions to minimize the risk of non-compliance should also militate against refusal to grant me bail in the present circumstances. I therefore humbly submit that this Honorable Court ought rightly to remain persuaded that in the overall and accumulatively the existence of the relevant factors circumstances is established, that therefore it will be in the interest of justice that I am granted bail pending the outcome of the application. As it may please the court, signed by Sindisiwe Precious Manuel and also commissioned as it were. And I beg leave to hand this as that constitutes the application.
I normally prefer that, next to the signature, date must be given. If you put a pen, the date of the signature.
Next to the signature, there must be date. As it may please the court. Is it next to the applicant's signature?
The applicant's
Yes.
signature.
Thank you, my lord. My lord, the application for leave, for bail pending the application for leave to appeal is opposed by the state. It is submitted that circumstances has now drastically changed in respect of the bail the accused had up until now, my lord. The court will recall a previous occasion when the application was brought for bail pending the sentence proceedings, my lord. One of the reasons was so that there could be access to the accused to enable and to facilitate consultations to take place between herself and then the expert witnesses in respect of drafting reports, more specifically for purposes of sentence, my lord. Now that sentence has been imposed on the accused, my lord, it is submitted that there's no need for her to be available for consultations by any witnesses in this matter anymore. The application for leave to appeal, my lord, is now simply based on the records, and appears that the only reason why that application can't be brought today, my Lord, is because that those records have not been typed as yet, being the judgment in respect of the merits, the conviction, and then also the judgment in respect of the sentence, my Lord. I agree with my learned colleague that the onus rests on the accused to show that there exist facts on the basis of which it has been shown on a balance of probability that the interest of justice permit the further release on bail, my Lord. My Lord, there's no hard and fast rule that say an accused should not start serving their sentences as soon as sentence has been imposed, and that they should first exhaust all their remedies in respect of appeal before they start serving the sentences, my Lord. It's admitted that in the present matter, the normal situation is applicable in that the accused should start to serve a sentence immediately, my Lord. The basis of the application for leave to appeal at the moment appears to be whether the accused exceeded the bounds of self-defense. Your Lordship is well aware of the test that is normally applied for an application for leave to appeal, whether there's a reasonable possibility, my Lord, reasonable prospects of success on appeal. And it's been stated in various cases that it's not sufficient to simply say there's a possibility of success, or that the case is arguable, or that the case is not hopeless. My Lord, that in itself does not constitute grounds for appeal, my Lord, and it's admitted that in the present case the accused was convicted on her own version that she exceeded the bounds of self-defense, my Lord. And therefore at this stage already it's admitted that there's not a reasonable prospect of a successful prosecution. There's therefore no reason at this stage, my Lord, it's not in the interest of justice that the accused again be granted bail pending the application for leave to appeal. As the court pleases, my Lord.
Why do you say there are no reasonable prospects of success?
Sorry, my Lord, I did not get that.
Why do you say there are no reasonable prospects of success at this stage?
My Lord, mainly for the fact that the accused was convicted on her own version. On her own version, it is clear that she exceeded the bounds of self-defense. It's also submitted that the proportionality with which she exceeded that bounds is substantial, my Lord, so it can't be an argument that the proportionality was only slight, and that therefore there's a possibility of a different conclusion in respect of whether she exceeded the bounds, my Lord. And it's admitted that another court acting reasonably will not come to a different conclusion as this honourable court can. Okay, as the court pleases, my Lord.
But your main reason why you oppose this application is that circumstances have changed.
Indeed, my Lord, from the previous situation.
From the previous situation.
Indeed. The previous time, my Lord, there was a need for the expert witnesses to consult with the accused, and the indication was that it would have been difficult if she would have been in prison at that stage because of the access regulations, my Lord, and on that basis, obviously, bail was granted. At the moment, for this application, my Lord, it's submitted that there's no need to access to the accused, as the application can be brought simply on the record itself as it once it becomes available.
All right, Mr. Nkuli.
Please, the court, my Lord, I beg to differ with my learned colleague that the court's indulgence of bail previously to the accused was merely a matter of convenience. It was a matter of fairness, because the Honourable Court found that it is in the interest of justice that she be afforded the opportunity to do so outside, to await her fate from outside the conference.
It was a Schedule 5.
And it still remains a Schedule 5.
Yeah, and that is
difference-
in terms of Section 11B. Section 11B of the Criminal Procedure Act.
Yes.
It was granted in terms of Section 11B of the Criminal Procedure Act. That is the one that speaks of the interests of justice.
Indeed, my lord.
Yeah.
It was not a question of convenience to the accused. It was in the interest of justice, and the Honorable Court so found. And the only seemingly significant change of circumstances is that the accused knows that she's facing a possible 12 years imprisonment. However, throughout she had been expecting and knew that the potential is 15 years. It's in fact lesser than what she was stood from the onset to receive. And having said that, the question really that arises not whether the application for leave to appeal will succeed or not. We are saying that we want to be able to prepare a substantive and comprehensive, so that it will be rather putting the cart before the horse to say that we won't succeed until His Lordship has pronounced on it. And I have sketched briefly where the basis of the appeal will be coming from, and other than the factual basis, there is also the fact that even though the accused has been convicted on her own version, the court interpreted the law into her version, namely that I accept that those are the facts, but here is the law. And we are going to contend with respect, my lord, that the application of that principle of proportionality to the facts proven was in fact erroneous, and that another court can and will can find otherwise. And we will demonstrate that in our comprehensive leave to appeal. At this instance, we are saying, having the history of the matter and the accused having shown himself to be the one that really exhausts their legal avenues to the hilt without any tinge of attempting to want to evade it, it would still be in the interest of justice to allow her that period of to lodge that application, upon which His Lordship will still have to decide whether there are merits or no merits in our application for leave to appeal against both the conviction based on the factual findings as well as the legal interpretation of the principles involved. And that is the farthest I can take.
So you are saying, like the last time, it was in the interest of justice?
Yes, and
it is in the interest of
and
justice.
it's still in the interest of justice. And if anything, if it is
It has nothing
non-compliant,
to do with consultations.
consultations are among the other factors that the court takes into account, but it is not the overall factor. It is the sense of justice and fairness that prevails as to whether in the circumstances, having the right to appeal and having had no indication or propensity towards avoiding the proceedings, why shouldn't the court still grant the accused that opportunity, the applicant that opportunity? And it's not as if this is something new or a precedent is going to be set by this court acceding to the application. It is within His Lordship's discretion and judicial power to grant us bail in the circumstances. As it may please the court.
You see, the essence of the argument by the state is that there is no need for the accused to be available for consultations because circumstances have changed now. You see? The last time the state believed that no, she got bail because she had to go and consult with experts and so forth and so forth.
Yes, and also within the limited period that we have of a month, insofar as what we need to do, there will be that need, but it is not neither here nor there. But I have taken it as far as I can and leave the rest in your hands, man.
What would you say is the amount of bail that the accused is asking for?
She is.
and the conditions attached to such amount.
She is currently, or she was on a
She was
bail.
out on a bail of 15,000 rand.
Yes, my lord. And it can, I'm instructed, she can be able to pay between 20 and 25,000.
She is able to pay 20 to 25,000.
Yes, that is, you can put a 10,000 on top of the 15,000 that we have. And in addition, we prepared that the reporting conditions be also extended. And we had already availed ourselves to a bracelet, as the court found last time, and the situation has not changed still. We are still availing
Was
ourselves.
she wearing a bracelet?
No, but the court ordered that she must avail herself for a bracelet. We availed ourselves. No one was forthcoming with a bracelet. And we are still saying that if there should be any need for a bracelet, they must still do so. The court did not say they must put a bracelet on us. The court ordered that should a bracelet be what the state wants us to be, that we should be attached a bracelet, we should accede to it. Or at least, in the court put it in such terms that say, you must avail yourself for a bracelet, monitoring bracelet. And we're still available for that.
Yeah, but why did the state not take the trouble of ensuring that it complies with the conditions of the court?
It would seem that the court left it open from my interpretation of the order, that if you say avail yourself for that, it means they have an option of putting us, and I can only assume is because they never considered us to be a flight risk. And they chose to do so.
Let's hear what Mrs. Skutte says on that point. Meneer Skutte? Mr. Skutte,
Yes.
are you talking to the investigating officer?
Yeah, sorry, my lord. I just had a brief consultation with him. My lord, the problem with the bracelet that came in on the previous occasion, that was never discussed with the state prior to the judgment being given. It subsequently transpired, my lord, that Correctional Services is responsible for dealing with issues in respect of the bracelet. And their attitude is that they normally, a bracelet is only applied in circumstances when the accused has already been sentenced. The accused in this present matter, at that stage, having not being in a sentence prisoner, my lord, they did not take the matter any further. And that's the reason why the bracelet was, the issue of a bracelet was never finalized and taken up with the Correctional Service, my lord. Obviously, the situation is now changed, and the accused being a sentenced prisoner, and that opportunity is still obviously available, my lord, although it has not been canvassed as a part of the conditions possibly for bail with them, my lord.
You mean the court order should be in so many words that the Department of Correctional Services must put on a bracelet on the accused?
Indeed, my lord.
It should be in so many words.
Indeed, my lord. I think the problem also came in because they're not a party to these proceedings, my lord. At that stage, the previous application for
Yeah,
bail,
but
my
the
lord.
situation has changed now, as you said, and she's a convicted person now.
That's correct, my lord. That is the instructions I have at this stage.
What do you say about the amount which was suggested by counsel for the accused?
With respect, my lord, the amount is irrelevant. 10,000 more, 10,000 less. With respect, my lord, I can't see that it's going to make a difference. Even if it's argued that's in the interest of justice, my lord, it must be shown by the accused precisely what interest is at stake here. By simply stating that we still want to proceed with our application for leave to appeal, we still want to go through the whole process of appeal, my lord, is that indeed a basis to grant bail, my lord, that in itself is admitted is insufficient. If that is the only basis on which this application is brought, that she wants to explore all the avenues available to her in respect of appeal or review, whatever might be the case, my lord, then obviously a precedent will be set that any and every person can bring an application for bail pending the finalization of the appeal procedure. That in itself is insufficient, my lord. Submitted that further grounds should be shown to argue at the end that it is in the interest of justice that the person be released on bail pending the finalization of that process.
We're talking of two things here. We're talking of bail pending an application for leave to appeal. Now, I haven't heard argument on leave to appeal wherein I apply the litmus test of substantial, not substantial factors, but of prospects, successful prospects. I haven't heard that. I am as yet to hear that. Right now, it's a question of bail. Those are two separate things. The one is intended to facilitate the other, as I understand it. That give me bail, and I'm going to bring an application for leave to appeal in future. That is a position.
Yes, that's where I understand it, my lord. But it's admitted, my lord, that the freedom of the accused is not a requirement for the bringing of this application. There's no grounds that has been brought forward or shown by the applicant, my lord, that it is required for her to be outside in order for her to bring that application. As I tried to indicate, my lord, the application would simply be brought on the basis of the judgments, which are presently not available. But there's no further need for consultation with the accused. An appeal is limited to the record. No amount of consultation will change that, my lord. And therefore it's submitted that there is no basis at this stage before this court to make a finding that it's in the interest of justice. Obviously at this stage, this honourable court is already aware of the basis, the facts are relevant to the matter, the basis of the conviction, the legal aspects relevant to the conviction, my lord. And the court has already a good understanding, although the grounds are not being listed as yet before this court. This honourable court already has a good understanding of what the issues probably might be, and therefore can, at this stage, for purposes of bail, already make a finding whether there's a need to release the accused on bail.
Has a precedent been set the last time when bail was granted? I mean, do the interests of justice change with the passage of time?
My lord, it depends on what basis bail is granted. The interest of justice is wide, and it can change from situation to situation, and it will differ from case to case, my lord. But if bail is simply granted on the basis that they want to bring an application for leave to appeal, and that the grounds thereof could not be numbered and specifically stated because the record is not available, it's admitted that in itself is insufficient, my lord. That on its own does not constitute interest of justice. That is basically the argument, my lord.
Yeah, I'm bothered and a little worried about the fact that the order which was given by the court was not fulfilled because it was subjected to different interpretations, you know, concerning the bracelet. That order was not carried out. Now, if you say circumstances have changed, to what extent have they changed as far as the bracelet is concerned?
Well, my lord, as I said, that I'm instructed that because the accused was not in custody, was not a sentenced prisoner, my lord, therefore the bracelet was not applied. because correctional services, my Lord, got their own internal rules. I understand, my Lord. I'm not aware precisely what that is at this moment, and I cannot address the court in detail, unfortunately, on that at this stage, my Lord. But those were...
Does the state
been advised.
accept that the accused is not a flight risk? I don't want to put you in a corner.
No, my Lord, I'm not going to concede to bail. I'm sorry. I can see where the court is going. I'm not going to concede to bail. My instructions are to oppose bail, and that is what I'm doing, and I consider that there's proper grounds to do so, that the interests of justice will not be served. The principles, my Lord, that is applicable, once a sentence has been handed down, the natural thing to happen is that a person should immediately start serving that sentence. That is the reigning principle applicable. Should there be an application for bail after sentence has been imposed, my Lord, there should be proper grounds. That being incorporated in the interest of society. Has to be shown by the applicant. And the onus is on the applicant to show on the balance of probabilities that there is in fact
Are you saying the applicant so far, through her counsel, has not shown any good reasons why the interests of justice are applicable in this case?
Indeed, my Lord. Principles being she's been sentenced. My Lord, that there's an application for leave to appeal that is pending, that it is not required of her to be outside for purposes of consultation, or what other purposes, none has been shown, and therefore submitted that she should start serving a sentence, my Lord.
Let's hear.
As a court, please, my Lord.
Just need to get something from there. The instruction was that on the issue of the bracelet, that you even went to the extent of sending messages to the authorities about what is the position with the bracelet, and we never respond. But be that as it may, the thrust of the application is that His Lordship is yet to pronounce on our application for leave to appeal. And at this stage, we have given the Honorable Court a synopsis of where we'll be coming from in our application, and it will still pronounce on...
No, let's get it straight. I said there are two things here. I'm not here now to pronounce on leave to appeal. I haven't heard that argument yet.
I agree.
Yeah.
I agree, my Lord.
I can only pronounce on bail pending
the application.
Leave to appeal, yeah.
As it may please the court. I've got nothing further to say. Unless if His Lordship wants to hear me on something specific.
Yeah, but on what was raised by counsel for the state, that the interests of justice so far at this stage, they don't demand that she be released on bail.
See, the problem with that argument is that His Lordship is yet to hear us, and the possibilities, as we've already shown and we submit, are that we might prevail. And at this stage, if we are going to prevail, we stand to be prejudiced by waiting for over a month whilst in custody, and eventually, when we bring the application, we'll prevail. And there is no one that loses anything by granting us the indulgence that we seek. And if we fail on the next date that has been agreed, well and fine, we can start the next processes.
You are applying for an indulgence from the court?
Not, it's an application for leave, for bail. I do not know, maybe the word indulgence is prudent to use, but it is along those lines. But the essence of it is that His Lordship has got a discretion in this matter, and His Lordship has got a feel of this matter, as it were.
Have the interests of justice changed since the last time? Look, the last time she was offered bail of 15,000 rand, and conditions were attached, including a condition on the bracelet.
The interests of justice are such that it will be in the interest of justice to afford her the opportunity to exploit her next step whilst outside the confines of prison, and there is no reason at this stage on the record to indicate that anybody stands to be prejudiced, because, as I have sketched, there is a possibility of us prevailing on His Lordship when we bring a substantive application.
Now, you are using prejudice as
in incarceration, and we say that
nobody-
can be
nobody
replaced
will be-
by giving us bail and a guarantee that we'll come back and do what we need to do, and then in exchange thereof.
In what way will she be in prejudiced by way of incarceration?
Incarceration in its nature is an invasion of the movement, as it were. And at this stage, we are saying there is no reason not to allow her to exercise her remedies as they are still available to do so, by, in exchange thereof, a setting bail, as it did happen in the previous instance, where she did not run away and came back and stood the trial. Knowingly that there is already 15 years that has been set aside, her duty was only to show the court that she deserves less than that. If she doesn't, she's getting 15. She did not run away. The situation still is the same.
You see, the argument by counsel for the state is that once a person is convicted, then that person has got to be incarcerated. It's the normal happening that happens.
I appreciate that, but at this instance, the accused has already given an indication to His Lordship that I intend appealing. It is not as if she's silent about it and she's not going to do anything about it. And having shown herself to be somebody that...
and it doesn't mean her appeal will be successful.
It doesn't mean that, and
that's
that's
why
not what
she's
you're
got
saying.
to get leave to appeal.
As it may please the court, my lord.
Mr. Scutter, I'm inclined to grant the bail pending an application for leave to appeal. I'm inclined to do so. Having listened to both of you and taking into consideration the fact that the last time I heard the argument about her bail, you know, circumstances may be different from what they are now, because right now she's convicted and sentenced, but the last time she was just convicted and not sentenced. So it's not a question of running away or disappearing into thin air like Macbeth's witches or anything of the sort. But my inclination is such that when I take into consideration the question of prejudice on the part of the state and prejudice on the part of the accused as a litmus test, you know, then she's entitled to her bail in the interest of justice, especially surrounding the prejudice which she's talking about, of incarceration, which involves deprivation of freedom and so forth. Makes me to be inclined to grant the bail, and I have not been shown what prejudice the state would suffer other than to tell me that, it's normal practice, we do that after conviction, you must just go to the mountain or anything of the sort. Unless you can show prejudice on the part of the state.
Oh, my Lord, I cannot take it further, my Lord. The point is that, that society demands that once a person has been convicted and sentenced, they should start serving that sentence, my Lord. That is the interest of society from the state side that is applicable. My Lord, it's been clear that where people are on bail and they need to proceed with bail applications or they need to proceed with the appeals, my Lord, that process becomes a very long one if it's not properly managed, my Lord. And it appears that as long as people are out on bail, they don't see the need to do it as soon as possible, and in the end, my Lord, we sit with cases that comes on appeal years after they should have been, because the process has been not been dealt with properly.
By the interests of justice and those of society seem to be one and the same thing. If I take the interests of society into consideration, we have a situation of people who have been convicted and sentenced, but who walk our streets around, and the victims of their crimes see them there and they ask, what is the law doing now? It's letting them out. They've been convicted and sentenced, and yet they are outside jail. And those are the interests of society, which have got to be taken into account as well. But I've yet to hear something about prejudice which would be suffered by the state, especially as compared to the prejudice which would be suffered by the accused.
My Lord, the state, if it is the prosecution, if that is what is meant by the state, my Lord, being the prosecution is not prejudiced by that. It's the interest of society that forms inherent part of the interest of justice. And that is the
I'm
point.
not talking about you in your personal capacity or the position you hold, you know, in your job or anything of the sort. I'm fully aware of the fact that you are not the state, but here you are the one, the mouthpiece of the state. You got to tell us what prejudice the state faces as far as such a thing is concerned.
Well, my Lord, the fact to get finality to cases and get people that's been sentenced to serve their sentences. That is why the courts are here, my Lord. That is why the state is here to prosecute these matters and to ensure that as soon as people are convicted, they proceed with their sentence.
Yeah. I'm like I said, I'm from the arguments, I'm inclined to grant bail pending immediate application for leave to appeal, and that by immediate I mean in less than a month or so. Both of you came to see me in chambers about a future date concerning the availability of a court for such an application.
Yes, madam.
And we agreed on a certain date, and we can't go beyond that.
As it may please the court.
So we said it's going to be the
12th of April, my Lord.
12th of April.
As it may please the court.
So, yeah. So if I were to grant bail, then it must be clear that the application for leave to appeal must, come rain or sunshine, be brought by the 12th or no before the 12th of April.
As it may please the court.
Right, Mr. Skitter, you may sit down.
That's good, please, my Lord.
Now, can you let's go through the conditions and the amount. You say the amount is got to be, you propose 50,000 to 20,000, 25,000 rand.
We would be happy with 20, but if the court is satisfied, it's 25.
Well, this is not This is
25, my lord.
Yeah. We are not bargaining here. This is not an Indian shop.
Indeed, my lord. 25 is the amount. And the condition to report was that we report every Monday and Friday, and we will be guided by his lordship as to whether that should remain or change at the police station.
Well, where's the investigating officer?
He is present here, Mr. Malak, and has always been.
What's your surname, sir?
Malaka.
Malaka.
That's correct.
Mr. Malaka, she has been reporting all along, isn't it?
That's correct, Your Worship.
There was no stage at which she didn't report.
No, Your Worship.
All right. Mr. Makubela, you say she must report on which dates?
On Mondays and Fridays, as previously.
Between what time and what time?
She reported before 5 of each of those days. Before 6. Between 6 and 6.
Between 6 o'clock in the morning and
And
6
6
o'clock.
in the evening, she must have reported regardless of what time.
Between 6 a.m. and 6 p.m.
As 1800, as it were.
and 1800, right. That's as far as the reporting is concerned. What else?
And those are the conditions. And that she must make herself available on the 12th of April for the application.
No. There were other conditions. There were other conditions. She was not supposed to leave the country.
Or the jurisdiction of Gauteng without informing Officer Malaka, who is present.
Yeah, and she was supposed to hand in her passport.
You still have the passport.
Indeed, the passport is still
It's still with you.
That's correct.
You say she's not supposed to leave the jurisdiction of
Is it Gauteng, without informing the
the
investigation.
Gauteng jurisdiction without informing the IO,
As it may please the court.
that is the investigating officer.
Indeed, my lord.
Yeah. And then the bracelet issue?
Will seem to be having difficulties. We're still available to subject ourselves to that. That will live in the court's discretion and guidance. But my instructions are that we are still prepared to wear the bracelet. But the state seems to have a difficulty. And it doesn't seem to have made any difference with or without a bracelet at the time. So that it would appear to be rather moot to insist on the bracelet where there are obvious difficulties in executing that order, my lord. And I submit that it might, in the court's discretion, be waived.
Which police station must she report between?
Mid-Rand police station. Okay?
That's correct.
Which police station?
Mid-Rand, my lord,
Mid-Rand police station.
as it may please the court.
Right, the amount has been set, then it's 25,000 rand. Yeah?
As it may please the court.
Then she's got to report on Mondays and Fridays, or Mondays and Fridays between 6 in the morning and 18 hours in the evening
As it may please the court.
at Mid-Rand police station. Yeah? Then she must not take the passport away from the investigating officer. It must be handed in which is already in. Ne? That's as far as the passport is concerned.
It is, my lord.
And she's not supposed to leave the Gauteng jurisdiction without informing the investigating officer. What else?
That is all.
Just look at the previous conditions.
Mr. Skipper, have you recorded?
My Lord, I only got my handwritten notes in respect of the conditions. Yeah, and it appears except for the amount of money, which was, what, 10,000 rand?
Just 15.
15,000 rand, my Lord, yeah. It's similar, except that I think that previously it was the Monday and the Wednesday. I noted it. But it doesn't matter, my Lord, whether it's Monday, Wednesday, Monday or Friday. It's accepted that Monday and Friday is appropriate.
And do you foresee problems as far as the bracelet is concerned?
No, my Lord, not now that she's been sentenced.
Now that circumstances have changed,
Indeed, my Lord, that...
so she will be able to get
yes, indeed, my Lord.
bracelet.
Yeah, indeed.
My lord, my instructions are that the accused had fielded a reminder to the investigation officer. I don't know who she should field a reminder and inquire about the bracelet, the correctional services or the investigation officer, so that there shouldn't be any misunderstanding and we are found to be foul of the conditions.
Who gives the bracelet anyway?
My Lord, the bracelet aspect is dealt with by correctional services, my Lord.
Correctional services.
They are the people who will approach the accused, my Lord, or the accused must approach them. Meeting will be arranged, and that the necessary steps be taken for the... Sorry, my Lord,
Mr.
might just have a
Malaka,
moment.
you want
I
to
see
say
the investigating
something?
officer wish to...
That's correct, Your Worship. Without being even the prisoner number, they won't issue a bracelet, right? Because it has to be linked to the system.
Yeah, so
That is
she
according to
needs
the
a prison
information
number.
that has- Yes, that's correct, Your Worship. She have to have the prison number so that they can issue with the bracelet, so that it can be linked to the system, so that they can be able to monitor the information.
Yeah. I'm inclined to put an onus on counsel or her lawyers to take her to correctional services for the bracelet, to ensure that she gets a bracelet there.
Will, after paying bail, arrange that we go there, and then if there are any difficulties, we'll advise everybody involved. But we will do that. And in any case, my instructing attorney is sitting in one of the correctional services committees, so I don't think we will have any difficulty.
So the instructing attorney must assist the accused to obtain a prison number and a bracelet.
Is the bracelet.
Does the attorney agree to that? I beg you? Right. I've got bail in the amount of 25,000 rand, and I've got 4 conditions here. The first condition has to do with reporting on Mondays and Fridays. Mondays and Fridays, between 6 o'clock in the morning and 6 o'clock in the evening. Ne? and you got to report at Midrand police station. Ne? Then you must hand in your passport, and you've already handed in your passport. It's with the investigating officer, right?
That's correct.
Then you are not supposed to leave the Gauteng jurisdiction without informing the investigating officer. Even if you have to attend a funeral in Newcastle or anything of the sort, you got to tell him that you plan to leave on such and such a day. Ne? And then an instruction is hereby given to your attorney to assist you to obtain a prison number as well as a bracelet. The prison number is for purposes of the bracelet, so as to secure your presence and to monitor your movements in Gauteng, okay? Any other thing?
We are indebted to His Lordship, nothing else.
All right. We cannot do more than that. Mr. Makubela, I think we should add as a phrase here that says these conditions are applicable up to that date which you've appointed.
The 12th of April.
Right. Madam, you're still out on bail. You must increase the 15,000 rand and put on 10,000 rand, so that it should become 25,000 rand. Ne?
Yes, madam.
All right. And the conditions have been spelled out to you. Ne?
Yes, madam.
And these conditions are applicable up to the 12th of April this year. Ne? 2016, okay? Right. Having said that, then the court is going to adjourn. Court adjourns?
All right.
Do you have the contact number of the person who deals with the bracelets?
No, I will try to get them, then I'll come.
Okay, then I'll just take it up with the defense as well. So we arrange a specific date.
Okay, that's fine.
What is the agenda for now?
12th of April for the application for the approval. So that would be heard on the 12th.
But tell me, what because I know in terms of like are there any sections in the criminal procedure that the person is convicted? You have anything like that?
In terms of the law, no, I don't have that is a normal course of the law. The moment you convict of that is what happens. You're supposed so there's not a specific law that says this is what must happen, but the bail law states you can apply for this. So it's not the law that says specifically that is but the normal course of events. You start serving immediately, except if you fill in an application for bail and to grant the bail, then that application. So there's not a specific law that states
Right, but inside it's not going to happen. There's no way to clear agency on.
It's on that.
It could be someone else there. Isn't it? No one picks up on it because we're all just sitting too, hiding behind the. That'll be a great. What's the same for a movie, eh? Judges apparently not calling me. I should put a zap.
Okay, never mind. Next.
Just get the orderly.
Hi, Utin.
What is